Good morning, everybody. Welcome. This is the Vermont Joint Committee on Judicial Rules for the Vermont Legislature. This morning, it is the last day of April 2021, and I am Joe Benning, outgoing chair of the committee, the Joint Committee on Judicial Rules. Just for the edification of those who may be watching on YouTube, we understand there is a potential audience here that is totally unfamiliar with what we are talking about. So for witnesses who may be presenting today, if you could try to keep the conversation at a 50,000-foot level for the basic education of some of those who are out there learning about us for the first time. We are set up for an agenda which begins with our body reconstituting itself. And the first action is going to be the election of officers for the next biennium. And so, Eric, I'm going to turn this conversation over to you. And for the audience, Eric Fitzpatrick is our legislative counsel. Eric.
Yes, thank you, Senator Benning. Good morning. This is Eric Fitzpatrick with the Office of Legislative Counsel. As Senator Benning mentioned here for the April 30th, 2021 organizational meeting of the Legislative Committee on Judicial Rules. What the historical practice has been traditionally is that the chair and the vice chair roles of the committee rotate each biennium between the Senate and the House. This past year, Senator Benning was the chair. Past biennium, I should say, so for the entire biennium. So if the committee were to follow that practice, this coming biennium would see a member of the House be the chair and a senator be the vice chair. I should mention that during the last biennium, the vice chair was Representative Haas, who did not run for re-election, so she's not with us this morning. So Senator Benning was chair, Representative Haas was vice chair. So again, that's just a practice, and it's been an informal practice. It's not part of the committee's rules or statutes. So certainly, there's no obligation that the committee follow that practice. But if you were to choose to follow it, that's the way it would play out for this coming biennium. So, having said that, the first order of business would be the nomination of a chair. But before, historically, before the chair gets nominated, oftentimes myself as the counsel leads that off and opens the floor for nominations. But maybe before I do that, I should pause for a moment and see if there's any discussion at this point of what I've already said, or whether folks have any thoughts.
Eric, I just want to take this brief moment to say I thank the committee for having its faith in me over the past biennium. It was a pleasure to serve. And as I say in all of my constituent conversations, it was an honor and a privilege. Thank you.
Senator Clarkson.
Thank you. And I would just like to say how much I'm missing Sandy Haas. And she served the legislature for, I believe, she came in with me. So she was with us for quite a while. And she served on this committee for a long time, really well, thoughtfully, attention to detail. And we will miss her. We happily still have Joe on the committee, which is great.
Thank you. Any other thoughts at this point? Seeing none, I would then say that the first order of business would be, and I should say also that usually once a chair is selected by the committee, then I would turn the rest of the meeting over to the chair, and the chair could then have the nomination of vice chair be the next order of business. And as I'm sure everybody's seen from the agenda, it's a short meeting this morning. Everyone has committee meetings at 8:30. So then I think you just turn to the witnesses from the court to talk about jury restart issues, Administrative Order 49, and should be able to get all that done by 8:30, I would suspect, but we'll leave that up to how it all unfolds. So having said that, the first order of business is the nomination of a chair for the coming biennium of the Legislative Committee on Judicial Rules. Are there any nominations?
Yes, there are.
Please, Representative Burdett.
Thank you, Eric. Yeah, I was under the impression, that this is supposed to be a simple nomination, and I really had trouble just doing a simple nomination. And I'll start out by saying I want to nominate Representative Martin Lalonde to be the chair of the committee. I've worked with Martin now for, gosh, it's either 5 or 7 years. I'm not sure which, but in that time, might call it a long time or a short time. I've watched Martin work, and there is nobody who works harder than Martin on a project or a bill. He just immerses himself, right up to his eyeballs, and he really is an incredible representative, for the work that he does for our chair, for our committee, and for the House. And with that, I'll repeat myself and say that I would like to nominate Representative Lalonde to be chair.
Thank you, Representative Burdett. Representative Lalonde has been nominated as chair. Is there a second?
I would be happy to second that nomination.
Senator Clarkson has seconded the nomination. Is there any discussion of the nomination? Or I think the next thing is, there any other nominations, I should say? Seeing none, any further discussion? Seeing no hands raised for further discussion, is the nomination of Representative Lalonde has been made and seconded for chair. All those in favor, please raise your hands or say aye.
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 All those opposed, please say nay or raise your hands. Seeing none, the ayes appear to have it. The ayes do have it, and you have elected Representative Lalonde as the chair for the coming biennium. So I will turn it over to you, Chair Lalonde.
Thank you very much. Thank you, Eric, and thank you, Tom, for the kind words. I'll remember those as we bring in the next gun bill. I'm just kidding. Just kidding. Only kidding. Only kidding. And thank you, Joe Benning. So the next order of business is any nominations for the vice chair for the current biennium. Senator Clarkson.
I would be happy to nominate Joe Benning, because Joe, I think one of the pluses of these committees is often some institutional memory. And Joe brings a lot of institutional memory and actual life practice on many of these issues. And we have a tradition of having a House or Senate chair and a House or Senate vice chair, and it's a good complement, and it's another opportunity that we can work productively together. And so I would like to nominate Joe Benning.
Is there a second? Senator Sears seconds the nomination. Are there any other nominations? Seeing none, all those in favor, please raise your hand or say aye.
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 And all those opposed, and seeing none, thank you, Senator Benning, unless you raise your hand to oppose, but you were outvoted. So I definitely appreciate Senator Benning being the vice chair, because I will look to him. I've been on the committee for 6 years, but certainly Joe has deep knowledge. So let's move on to the agenda. And I believe our next order of business is to hear from Justice Eaton regarding, is he going to speak specifically to the Administrative Order 49? Is that correct, Eric? Well, I understand that.
I believe
if I might suggest, I think
sorry.
this is Patricia Gable, State Court Administrator, and I believe Emily Weatherill is prepared to give you the summary of AO 49, and then Justice Eaton, Judge Gerson, and I are available to answer questions related to that, if that please the chair.
So, Patricia, should we start with Emily or start with Justice Eaton?
I believe we should start with Emily, if
Okay,
again, if
great.
it please the committee.
Great. No, that's fine. Thank you. Emily.
Hi, good morning, everybody. My name is Emily Weatherill. I'm the Deputy Clerk of the Supreme Court. And welcome to the new committee members. It's nice to see some new faces on the committee, and it's nice to see the rest of you again. And thank you, Chair Lalonde. I just want to give a brief overview of the amendments that were made to AO 49 since the committee last met in December. There have been 3 amendments that were made to AO 49 since that time, and several of them relate to jury trials. So I'm just going to go over them really briefly. And then as Pat Gable mentioned, she is here, Judge Grierson is here, and Justice Eaton is here for additional questions that the committee might have. Just as a reminder, AO 49 was enacted a little over a year ago in response to the pandemic under the court's jurisdiction under the Constitution to administer the courts and generally to provide for rules for the state courts. On December 22nd, the court made an amendment regarding remote hearings. At that time, in the course of the pandemic, the decision was made based on the recommendation from public health that the court should do remote hearings whenever possible. So there was an amendment made there to create a presumption for remote hearings, except for jury trials, and for a narrow exception in cases where criminal defendants or juveniles in delinquency proceedings had a right to be present, required by law. On March 8th, the court made an additional amendment that extended the effective date of the order until May 31st. So that is the extent of the order at the moment. It will extend until May 31st. There was also an amendment that was made regarding e-filing. At that point in time, all of the superior courts in the state were on the e-filing system. And so some of the emergency amendments that had been made allowing attorneys to submit documents by email were no longer in effect now that documents could be submitted through e-filing. The amendments were left in pertaining to self-represented litigants, allowing them to submit documents by email, but for attorneys, everything needed to be submitted through e-filing. And there was also an amendment made at the recommendation of the Civil Rules Committee to a civil rule that regards the extension of offer of judgment. I don't know if the committee wants me to go into that one in particular, so I'm going to move on unless there are questions related to it. And then on April 8th, there was an amendment made regarding jury trials, and this amendment allowed the chief superior judge to transfer a case from one unit to another in order to be able to proceed under proper public health recommendations. So some of the units did not have the capability by space to maintain the public health recommendations. So this allowed the chief superior judge to move those from one unit to another. So that's sort of an overview of what the court has done since the committee last met on December 8th. And I'm happy to go into some of that. I know the committee's time is fairly tight this morning before 8:30.
So are there any questions for Emily? Senator Sears?
Yeah, I did receive a letter from a man from North Clarendon, an attorney who was really concerned about juvenile court and the ability of folks to be there when it's supposed to be confidential. Have you heard any other complaints like that?
So I haven't, Senator Sears. This is Pat. I don't know if Emily or Judge Grierson have, but I haven't heard anything.
Okay, well, he's from North Clarendon. I will try to scan this and get to you. He is Eric S. Louttit, and he says that remote hearing from juvenile court, someone may be in the room and not visible when they're appearing over WebEx. So anyway, you had not heard anything, no complaint.
No, and we're managing the WebEx. We hope, our intention is to manage the WebEx so that in confidential proceedings, only the people who are supposed to be there appear. And so I guess there's two possibilities. One is it's a theoretical concern he has because he can't tell. And the other is there was some error made. We don't live stream those proceedings. And so normally you can tell who's on. So I look forward to receiving your correspondence and we'll take a look at it and track it down.
Assuming I can technically scan it into my computer and get it to you.
I understand.
So are there any other questions for Emily? I'm not seeing any. So were you gonna give us an update, Patricia, on the remote civil jury trial committee? I know that you sent us a document. I don't know if everybody had a chance to look at that.
Yes, that is, Justice Eaton is prepared to address both the remote and the in-person jury trials.
Yes, I
Excellent.
am. Thank you. Good morning. I know that you received an email yesterday updating you on the work that Justice Carroll's committee is doing on the remote civil jury trials, which is proceeding apace and looks very promising. They are going to be doing a mock-up trial on May 20th, and they've already got their witnesses and attorneys and all those folks who are willing to participate. And that will be a dry run on ironing out any bugs that might exist. At the same time, the committee's working on all the procedural issues that need to go on. Including how to summons jurors and how jurors will be able to access the internet for remote trial work. So they've done a tremendous amount of work in a very short period of time, because we've only been really developing this track since February of this year. So in a couple of months, they've really come a very long ways. And it looks to me as if that is going to be a part of the judicial landscape long after the pandemic. I think that it's going to result in convenience to litigants, to jurors, and to the court. And I suspect that it will have a role in the long term. So that is a way to help ease the backlog when that comes online. I know that you received some information from me about, by way of an email, about locations that have been approved for jury work, and about some jury draws that have been scheduled. That was sent to you yesterday. Since then, there has been an additional site that has been approved for jury work that I just received in the last 20 minutes. So that is promising news and brings to 10 the number of available courts to do jury work. I know that there is concern about civil juries and whether a civil juries of 6 people is something that should get done. And I wanted to identify, if I could, just a little bit about the scope of that issue, because I've been involved in listening to some testimony about the concerns around the civil jury trials. And I did just want to put some parameters on it that may not have been discussed previously. In 1994, there were 40 civil jury trials in Chittenden County alone in 1994. In 2018, there were 19 cases statewide that went to jury in the civil docket. In 2019, there were 20 cases that went to jury trial in the civil docket. And going back to 2018, that was 19 out of over 5,700 actions that were filed. So the 99.6% of civil cases were resolved without jury trial during that fiscal year. So for reasons that have absolutely nothing to do with the pandemic, the number of civil jury trials has been going down and down and down over the last 25 years. And it's not just in Vermont, it's a nationwide phenomenon. So I know that there is discussion about reducing the juror numbers in civil cases from 12 to 6. I was and am one of the co-chairs of the Restart Committee. We made that recommendation to do that a few months ago, and the court has not taken action on it formally at this point. But as with other things, there's been a lot of change that's happened very quickly And they are, as I said, the remote jury trial going from an idea to a reality. And the increase in the vaccination in the population, which has increased public confidence in terms of participating in juries, the number of sites that have been approved, and the loosening of venue. All of those things will help to address getting civil cases tried to the extent that there are civil cases to try.
So I appreciate that. And I do have a question, but I'm going to let the senators go first since they only have a few minutes left. Senator Benning.
Thank you, Martin. Justice Eaton, the State House resumption of activities is premised, at least in part, on the governor's executive order being lifted. Is the court system subject to the same triggering mechanism if the governor suddenly declares that his executive order has evaporated? Is the court system's administrative order 49 going to remain in place, or does that go away as well?
It's a good question, Senator, and the answer is no. It's not tied directly to what the governor does. I will say that in certain places we have been out ahead of what the governor's executive order might have required. But I wouldn't be at all surprised if we largely follow suit.
Okay, thank you. Martin, I have to leave. Thank you all. We'll see you again.
Thank you. And I believe that Senator Sears left as well, because I had a question for the senators. I understand that the six member jury is in the budget bill coming over from the Senate. Am I correct about that, Senator Benning or Senator Clarkson, before you head out? I'm just kind of curious what the status of that is, because I know it was moving at one point.
I don't know the answer to that. Do you, Joe?
I think it is, but I'm not on the appropriates committee, so I'm a little reluctant to commit to that answer.
We can find out quickly for you.
Yeah.
But and just quickly,
Eric may know.
Eric probably knows.
Yeah, it's in, but it's in as legislative intent. So intent that a portion of the appropriation for the court to come back online after the pandemic be used for a 6-person jury. So it's our intent, not a specific requirement.
Okay. All right. Thank you, Eric.
Yep.
So I know that we have a bill over in the House as well for that, but we haven't really taken it up. So Senator Clarkson, you had your hand raised.
Yeah, sadly, we have to go, but I'd just like to ask Justice Eaton, why have civil juries gone down? I mean, there's actually quite a bit to discuss today. I'm really sorry that we are having to go, because we're poised on the precipice of these jury trials starting up again, as I understand, at the end of May.
Yeah.
Is that right, Duke? I think.
Yeah, yes. Yeah. A short answer to your question, which is also an excellent one, is a couple of reasons. One is alternate dispute resolution. The ADR process, mediation, has played a huge role. Second is that so I think that there has been a shift in the litigants' desire to control their own outcome. Rather than give it to a jury. There's been a lot of studies that have suggested that people are much more comfortable feeling like they were the ones who decided what the outcome would be, rather than to give it to a jury. So there's some risk aversion there that is going on, and some controlling of the outcome. So as I said, it's not a Vermont phenomenon, it's a nationwide phenomenon.
Yeah.
There's been a lot of work looking at the issue.
Right. Thank you.
So did you have a question, Senator Rahm?
Just waving goodbye.
Waving
Yeah,
goodbye. Okay.
Sadly,
Well,
have to go.
We're probably almost done, but I do have one follow-up question from what Senator Clarkson just asked Justice Eaton. So I understand that scheduled civil jury trials often get the parties to focus on settlement. Have you seen a decrease in cases being settled over the past year, or resolved without a trial over the past year, because we haven't had the pending trial hanging over the head of the litigants?
I know that there has been testimony to that effect, that has been the case, but I have not studied the actual settlement numbers versus what we might ordinarily expect at this point. I do agree, though, in not only in the civil docket, but also in the criminal docket, the threat of or availability for a jury trial is a large fulcrum in getting cases settled. There's no debating that. That's just facts.
I appreciate that. I see Judge Gerson came on. I wonder if you have a comment on that, Judge.
Well, on that particular issue, good morning. Thank you for inviting me. For the record, Brian Grierson, Chief Superior Judge. Just to follow up on what Justice Eaton was commenting on, that if you will, the threat, if you will, of a jury trial, either in a civil or criminal case, certainly drives settlements. And by way of example, some of you may be aware from testimony I've provided earlier that the Wyndham Court, the state courthouse, was our first courthouse to be approved for jury trials back in March. And they started, this started with, I want to say about 10 cases on a list that both the judge and the attorneys involved thought would be appropriate for this initial jury trial. That list began to shrink very quickly. Cases were settled as a result of the possibility of them being called in for jury work. Some of them were continued for other reasons, but by far the majority resulted in settlements. And these were all focused on in custody, individuals who were in custody and obviously had been in custody for some time. But as that list came down, and under the authority of AO 49 and the general statutes relating to change of venue, as that list in Wyndham was going down, as we approached the jury draw date, I reached out to Windsor County and Bennington County to say, look, there's an opportunity here for jury trials, and it looks like the Wyndham cases could settle. You should work up a list yourself. And in Windsor County, I think they started out with, again, approximately the same 10 or so cases. And they either resolved by way of settlement, or one or two had to be continued because they're perhaps out-of-state witnesses. But there's no question that we have seen just in the last couple of months that when there is the opportunity for jury trial, it motivates settlements in both dockets.
I appreciate that. Maybe you should just open up all the courts and schedule all the jury trials, because none of them will actually go to trial.
Trust me, I have thought of that, but the court has frowned on me making that announcement. So I'll keep working on that. But.
I appreciate it. So I don't think we should continue without our friends from the Senate. So if I recall right, Eric, we usually take a motion to adjourn from our committee work. So I will take a motion to adjourn.
Yes.
All right. So I see that Maxine Grad, is there a moved, and is there a second?
I'll second that.
And we have a second. And all those in favor of adjourning,